you're walking down the street, you slip and fall. Is that a slip and fall case? In this video, we're going to talk about some of the criteria that makes up a slip and fall case. My name is Eric Mausner. I'm a personal injury lawyer in Miami, Florida. I work at a law firm called Mausner Graham Injury Law. We handle all kinds of injuries and accident cases. On this channel, we provide all kinds of insights regarding personal injury, law, and various topics and issues. So what do you need to prove in a slip and fall case? Slip and fall cases break down to three components. The first one is liability. Who's at fault? How are you proving it? In slip and fall cases, you have to prove actual or constructive notice of the dangerous condition against the landowner or the individual or the company that maintains the land. This can be tricky. Number two, you have to prove injuries. In these slip and fall cases or trip and fall cases, you need to have real injuries to justify bringing the lawsuit and making it worthwhile to recover. You have to have damages. So you need to be treating hospital, physical therapy, orthopedic doctor, neurology. You have to treat your injuries and prove your damages in a slip and fall case. And number three, you have to have insurance. You always need to be suing a business that is either very cash rich, self-insured, or typically they're going to have an insurance policy, a general liability insurance policy of up to $1 million. You want to be suing or going after a property owner that has insurance. So what kind of cases do we see as slip and fall cases? Let's talk about airport slip and fall cases. Airports have lots of people, substances, liquid, objects, things fall on the ground. The airport has cleaning companies and lots of employees, and these companies are responsible for keeping the airport clean. If these substances, let's say someone drops coffee on the ground and it's there for a very long period of time and people are walking through it and then eventually somebody slips and falls, the airport and or its cleaning company could be held liable for not cleaning up that coffee spill. Another example of a slip and fall, or let's call it a trip and fall, can be a shopping center. Shopping centers have uneven sidewalks. Elderly people are walking along those sidewalks all the time and they often will trip on the uneven sidewalk. In this case, you have to bring in an expert to establish that there was a code violation, and you're also going to want to be able to find who the guilty or liable party is. It could be a shopping center management company, it could be the owner, and it could be the individual retail stores that are perhaps responsible for maintaining or fixing that uneven walking area. Other slip and fall cases can be in hotels, restaurants, any kind of private property. How about stadiums, concerts? Slip and falls can happen on any kind of private property. They can even happen on boats, especially cruise ships. So what do you need to have a successful slip and fall case? You have to start with liability. I mentioned this earlier. You have to prove actual or constructive notice of a dangerous condition, or you have to prove a code violation. And to do this, you typically need an expert. Personal injury attorneys hire expert engineers to go and inspect the property and build liability against the landowner. Without liability, actual or constructive notice, your case could get thrown out of court. So what are negligent security cases? Negligent security cases are actually like a subset of premises liability cases. Premises liability cases are where people get hurt on other people's properties. So if the landowner or the landlord doesn't have adequate security or has insufficient security, has a history of crime on the property or other incidents, they can be held responsible when someone gets hurt due to inadequate security. So how long do you have to file a lawsuit in Florida? The law changed in March of 2023. Any incident after March 2023, you now have 2 years in Florida to file a lawsuit for negligence. So what if you didn't see a doctor right away after the incident? We always advise our clients, treat right away. You have to prove your injuries, especially in a slip and fall case. Slip and fall cases require serious injuries because you spend a lot of time and money advancing the case in court, and you want to be able to recover enough money for your client that justifies bringing the case to begin with. Because you could spend more money and time than you would recover, and it depends really on your injuries. The law and the insurance companies look at more, they value serious injuries much more than, let's say, less serious injuries like a bruise or a bump or something that would heal in a month. If you brought a case on a less serious injury, you may not recover enough money. So who pays your bills in a slip and fall case? Typically, it's an insurance carrier if you have health insurance. If you don't, you can treat with doctors who may defer payment until the end of your case. So your settlement money or your potential settlement money would pay for your treatment. So how long does your slip and fall case take? Typically in Florida right now, I would give it 1 to 2 years. It just depends on the courts, it depends on your case, depends on how fast you heal. Maybe you have to do a lot of treatment for more than, let's say, 6 to 12 months. So there's a lot of factors, but on average, you can safely say your case might be 12 to 24 months in litigation in Florida. So can your slip and fall case be done or finished or settled in under a year? The answer is yes. It depends, like I said earlier, on the factors. How fast is the law firm moving it? Are you healthy? How fast is the court moving? Is the defense attorney and the insurance company delaying? You can get a slip and fall case done in under a year. But typically, if you're going to go to litigation, it could take 1 to 2 years at least. And if it goes to trial and appeal, much longer. So you can't afford a lawyer. What do? Don't worry. Personal injury lawyers work on what's called a contingency. We only get paid if we recover. If we don't recover, you owe nothing, no fees, no costs. It's a wonderful way to work with clients. They don't have to pay us anything up front. Our interests are aligned. It's our job as the personal injury attorney to go out and recover money for you. Thanks for watching. Please subscribe to our YouTube and follow our social media for more insider tips regarding personal injury law.